The following program is a Town of Colony television production of the William K. Sanford Town Library.
Good afternoon, everyone. Nice to see all of you here. I'm Jeff Baldus. I'm the Deputy Director of Death with Dignity-Albany. You're more used to seeing our Director, Bonnie Edelstein, up here. So I am at the podium today. It's nice to see all of you at today's program. As you know, or as most of you know, Death with Dignity-Albany is a grassroots organization. And our mission is to provide a forum for sharing information and for discussing end-of-life issues and to advocate for the expansion of end-of-life choices. Though we are a relatively small organization, we're growing. We have over 500 people on our email list. And we also work with the national organization, Compassion and Choices, in most of our initiatives. Isaac Asimov, a noted author, professor, and biochemist, once said, "Life is pleasant, death is peaceful, it's the transition that's troublesome." Today's program, entitled Controlling Your Destiny, Legal Documents That Work, is about that transition. Assuring that your wishes are carried out and that legal documents are in place to help to guarantee that. And as we have learned through many presentations and as part of Lou's presentation last year to the group, estate planning is about more than just money. We tend to think of estate planning, we think of the dollars and the cents, but it's really about much more than that. And as you will discover today, there are far many more components to that plan. We are pleased to welcome back Attorney Lou Pierro, whose presentation last year was met with a great deal of enthusiastic acclaim, and because of that, we asked him for a second round today to both repeat some information and tell us anything that may be new. Lou Pierro is the founder and principal of Pierro, Connor and Associates. Their primary office is not too far away in Lakewood. And he concentrates his law practice in the area of estate planning, estate and trust administration, business succession planning, elder law, special needs planning, and so on. When we talk about Lou Pierro, frankly, we talk in superlatives. Mr. Pierro has been selected to best lawyers in America, the best lawyers in New York, super lawyers of the Hudson Valley, top 25 lawyers in upstate New York, and New York Times top attorneys in New York. In addition, Mr. Pierro was named Best Lawyer 2016 Lawyer of the Year in Elder Law for the Capital Region. So we have a true giant in the legal profession with us today. A lot to live up to. He has served as an adjunct professor, lectures extensively on estate planning and elder law. Please join me in welcoming Lou Pierro.
Thank you.
You're welcome.
Boy, that is a tough introduction to live up to. I feel like I should pull my shirt off and show you the big red S that's on my chest. Welcome to this program. I'm very happy to have you here. I'm happy to be here again with Death with Dignity. And today's topic is planning. And we should all have plans in place. We should all be thinking about how we can make sure that our wishes are carried out. And at the end of today, hopefully you'll walk out of the room with a clear vision of what things you need to do to make sure your plan gets done. Before we get to that, I want to talk a little bit about aid in dying, talk about the landscape upon which we're having our discussion here today, and talk about the fact that we never know what our fate holds. We may be in a situation at some point where others are making decisions for us. Are they the right people? Have we provided them with the right guidance on how to make decisions for us? I'm afraid that most of us have not really thought those decisions through to conclusion. I had a situation in my life in March that put me in a position, sitting in a hospital room, waiting for open heart surgery, which ended up being a quintuple bypass and a valve replacement. And I was sitting in a situation where I had to really confront these decisions for myself. Talking to my family members, my wife, my children, thinking about the directives that I had in place. Fortunately for me, I'm in a community of lawyers in our office and had documents that I didn't have to change. But I reviewed them as I'm sitting in the hospital room, confronting a real possibility. And that hits us like a ton of bricks. And for many people, it's too late. For me, I got a second chance. I got a reprieve. And now I'm better than before, because they can fix things. And medical science can do things to us to put us back on our feet. And in many cases, that puts us back, like me, in a situation where I now have better blood flow than I've ever had in my adult life, probably, because I have brand new arteries. But that doesn't always happen. So let's look at the landscape and where we are in our American society. And this is not just an American issue. This is a worldwide issue. This issue permeates every country. Countries like Japan have a population aging much faster than ours. They have fewer young people to pick up the burden of caregiving. And they're looking at some pretty radical solutions to aging in Japan. China had a one-child policy for a very long time. They don't have the caregivers in the next generation. Our Census Bureau did a study a very short time ago and looked at what happens when you get to be age 65. How long can you expect to live beyond that time period? And just to put this in perspective, Medicare and Medicaid were both enacted in 1965, 51 years ago. When they were enacted, Medicare came in at age 65 because that was life expectancy. When Social Security was passed in 1934, life expectancy was in the 50s in 1934. So the programs that we have available to get us through this time period are going to be under tremendous stress, already are. Unfortunately, politics doesn't allow for a very enlightened discussion of this problem. It's a he said, she said, you did this, you did that. Where do we get real debate? Where do we get real dialogue on the issues that are going to shape this country for years to come? If you're a female and you're 65, you're going to live by the book to age 88.8. Now, that's another 23.8 years beyond your 65th birthday. Will you be in good health for all of those years? Will you be independent for all of those years? And we have clients living well beyond 100. We're doing a case right now with a woman who's 102, and we're planning for her, for the future. She's in good health. We have many clients in their 80s and 90s, and we're doing planning for them. It's never too late until it is. If you're a man, you live a little bit less, 86.6, but still a long life expectancy beyond your 65th birthday. So when you think of programs like Social Security that come in your 60s and Medicare that comes in at 65, these people, we people, the baby boomers, who are turning 65 at the rate of about 10,000 a day, began turning 65 in 2011, and are now turning 70. And in 10 years, that front edge of the wave will be turning 80. And there are 78 million of us coming through the pipeline. So in 2020, we're looking at 56 million Americans over age 65. And in 2050, they're projecting 86.7 million seniors over age 65. So when we talk about this and we dialogue about this, these attitudes and mores will shift as reality shifts. As the number of people who are staying alive, surviving on Medicare and on their health insurance into their 90s, into their hundreds, the issue of quality of life will become much more prevalent and will enter our discourse. Right now, there are a lot of very rigid ideas and morals about end-of-life decision-making, at least in our country. We're going to talk today about end-of-life decision-making in a variety of contexts. And we're going to look at what death looks like today compared to what it looked like years ago. It's a pretty sharp curve there. 90-degree turn, that's a sudden death. And that could happen to anyone. Could be an accident, shooting, violence, massive heart attack, massive stroke. But that's a very extreme situation, and that's a very rare death in today's world. Because in many cases, you can be saved. The EMTs can save you. They can put you back in a position where you are still alive. So that death is becoming more and more scarce. This is a rapid decline, progressive disease with a terminal phase. And my father died of heart disease, hence my open heart surgery, heredity being what it is. And so that was about an 8-week course from the time he had the heart attack to the time that he died. And it was a rapid decline, last 2 weeks in the hospital. And people do have those illnesses that they cannot turn around, they cannot save in medicine, and it still does happen. This is what we call the dwindling death, which is advancing age with onset of chronic conditions. So this is something that has been around for a while, but this is the new norm. Because medicine can pick you up off the floor and put you back on your feet, or at least in a wheelchair, and you can be alive for very long periods of time with medicine in and out of the hospital. Many of our clients, oh, what time is it? It's that time of the month. They're in the hospital again. And they need a treatment, and they go back home, and then they go back to the hospital. And we have these rapid declines. I call it the roller coaster. And as family members and as caregiver children, you ride that roller coaster with your parents, and it becomes part of your life. And dealing with those situations becomes very difficult. And my mom died of Alzheimer's, and so this was an 8-year course, and she had other health issues in between, and her health was up and down, and we dealt with it as a family. But it's very difficult, and it can be very expensive. As medicine advances, as we get better at cancer treatment, at heart treatment, the diseases that used to kill us no longer kill us. Many things that we take for granted today that are not part of our worries in terms of our health that have been cured. Not everything, but many things. So as medical science keeps us alive, we have to deal with this kind of a progression. And the longer you live, the more likely this is your chart. Because when you get to be 90, although my aunt who's 94 is still sharp as a tack, goes everywhere, walks 2 miles a day. But we have a lot of other clients who we get 24-hour-a-day care for in their home, or they end up going to a nursing home because their chronic conditions and their physical health begins to fail them. So dealing with all of these things requires preparation. And we're going to talk about the legal documents that you need to have to navigate the new norm. So as medical science increases longevity without ensuring quality of life, the dying process takes on new meaning. Care and end-of-life legislation. When we look at the things that are happening across the country, as was talked about, states are picking up these laws, and it goes back, the original case that was a U.S. Supreme Court case, and many of the cases that we talk about in this area of law involve young women, just coincidentally, and it goes back to 1976. Anybody remember Karen Ann Quinlan? In New Jersey, and her parents tried to get artificial life support removed, and they failed. Fast forward to 1990, Nancy Cruzan and her parents, she was in a persistent vegetative state. Her state said, no, you cannot withdraw artificial life support. They took it up to the United States Supreme Court, and the United States Supreme Court sent it back and said states can enact legislation that allows people to withdraw artificial life support and to preordain that, to have a document and an agent appointed to withdraw artificial life support. So Cruzan was a watershed case and really opened up the idea that people should be allowed to die. And that's a theme. They were allowed to die. Oregon has a Death with Dignity Act passed in 1994, the longest standing on the books, upheld by the U.S. Supreme Court in 2006. So states have a right to legislate in this area. And that was the other watershed Supreme Court case. Then you have Washington, Death with Dignity Act in 2008, Vermont in 2013, Montana, Rights of the Terminally Ill Act in 2009, and the Death with Dignity Act in 2015. We have New York legislation pending. This is, however, a case that was just decided in June of this year in New Mexico. And this is the flip side. And we don't know how high up in the court system this is going to go. It's not the U.S. Supreme Court, it's just a district court in New Mexico. But what it says is that there is no absolute and fundamental constitutional right to a physician's aid in dying. And in this case, the New Mexico law was different than some of the other laws. And what they were seeking to do here is prevent aid in dying. And the court said you do not have a constitutional right, that it is up to the state to enact legislation. So we can't compel the states. We have to cajole the states through our votes and through lobbying efforts to pass legislation for this very important right. So the arguments here from the petitioner: death from a physician in aid in dying does not equal suicide. And the New Mexico statute was only intended to address suicide. But when you think about aid in dying, and we're going to look at the different modalities here, it's the prescription of medication that is then taken by the patient. It is not the administration of medication by the physician. A very, very important distinction. The Montana Supreme Court position should be adopted in New Mexico, and that was upholding their right to die legislation. Court held protecting patient autonomy and medical decision-making justifies the conclusion that physician aid in dying is not prohibited by Montana's statutory prohibition, and urges this court to do the same. Court rejected that argument as well. So the New Mexico case holds and stands for the proposition that you don't have a constitutional right to aid in dying. Those other states have passed statutes. New York is contemplating a statute that grants that right through state law. So the legal framework for aid in dying. There are protections in these laws. And in your handout, you have a number of them built into the New York proposals. There are a lot of critics of aid in dying legislation, and there are a lot of arguments that have been posed against such legislation, but a lot of the protections that are built into the law alleviate most of that criticism. And so this can only be done by a patient who is competent, who is making the request. This is not done through surrogate decision-making. Very important distinction. And so disability advocates groups were one of the groups that were lobbying against the legislation because they felt that euthanasia was going to be part of this, and that people who didn't have the ability to be willful and do it of their own intent were going to be subjected to aid in dying. That's not how the law works. It's very, very different from that. So there have to be two physicians, there have to be witnesses, non-family member, independent witnesses. All of those safeguards in the Oregon law are in the New York proposals as well. And so it's something that you have an ability to do in certain states. Well, Oregon, being the state that was out in front of this and has become known for their legislation, drew a young woman, again, talk about the young women, by the name of Brittany Maynard. Anybody here ever heard of Brittany Maynard? If you Google Brittany Maynard's name, you'll get the story. But she was wanting to have physician-assisted suicide in California. And the law wasn't there yet. And so she very publicly moved her whole family, was in the press, was out in front of the issue, made her story a very popular story. And she moved to Oregon and became an Oregon resident, opting into Oregon's law, and chose the time of her death and executed her aid in dying with her physician in Oregon, with her family present, under her terms, and it became a widespread story throughout California. And shortly thereafter, the California legislature passed their aid in dying legislation. And it's sometimes that one lightning rod, that flashpoint, that turns the opinion of the legislators and that coalesces public opinion. And most people, I believe, favor aid in dying legislation when they're polled. But it doesn't work its way into the legislative process quickly. So California has it now. They passed it. And it's not only aid in dying. Let's talk about some of the other things that are available to us in New York and in most other states. Advanced directives. Uniform Health Care Decisions Act permits patients to have advanced directives. That was passed on the heels of the Nancy Cruzan case. So in 1993, New York passed its healthcare proxy statute. We're going to talk in much greater detail about the healthcare proxy. That is our advanced directive, and we can do many things with that healthcare proxy. It's a law that has worked very, very well for our clients. You can draft it. The Department of Health hands out the form. It's very simple, but you can also go beyond the statutory form that the healthcare department gives out, and you can build into that healthcare directive your wishes with regard to a number of different situations. And again, we're going to appoint agents to do this, but we want to guide them. We want our wish to be their action. And you can do that through the healthcare proxy. We'll talk more about that. The Pain Relief Act protects physicians who prescribe medication for persons of pain relief under accepted standards of practice in situations even where the patient's death may be hastened by the treatment. So we have something called palliative sedation. Anybody ever hear of palliative sedation? Most of you have. If you're here in this room, you're an enlightened audience. Also called terminal sedation. Terminal sedation. Doesn't that sound a lot like aid in dying? How close is it? So when we look at palliative sedation, it's the withdrawal typically of nutrition and hydration. It's the time to die. So the decision has been made to allow the patient to die. And strangely, to allow them to die, the physician gets to actually administer medication, pain medication, because these are patients that are in pain, do not have adequate relief, and their suffering and distress cannot be alleviated by the modalities that have been implemented. So usually there are tries to do pain management in these cases, but when the pain management fails and the person says, I've had enough, the physician can prescribe their Seconal, IV, that's not Roman numeral 4, that's IV, over 7 days, and withdraw nutrition, hydration. You're managing the distress, managing the anxiety, managing the pain, and allowing that individual to die over that time period. Usually it occurs in 7 to 10 days. When you go to the aid in dying, we're not now giving the patient, we're not now administering to the patient the medication, an IV drip. We're handing them the medication. We're prescribing it and allowing them to take it on their own. And in this case, the patient takes the medication. It's a lethal dose, so it's not a 7 to 10 day period. It's an immediate death. And it's for patients with terminal illness who want to control the time, place, and environment of their death. Having gone through this with family members and having some of them taken 7 days, 10 days, 2 weeks, this process is, number one, grueling, and in some cases, they medicated them through the palliative manner till they were unconscious, so that they didn't have to suffer through this. Many of them, I think, if they had this option, would have chosen the time and the place and the manner of their exit. They were exiting anyway, but this is not allowed in New York. So this is the legislation that we're looking for. And think about the differences here. This is the practical difference between the palliative sedation and aid in dying. Not a very bright line. Where is that line? How do we draw that line morally, ethically, beyond my talk, beyond my ken? But those are the issues that are being debated in the legislature. To cross that line, to allow aid in dying to go beyond the palliative sedation. Oregon and those other states have done it. New York has it queued up, and we'll see where that ends up. So there is a Palliative Care Information Act. Question?
You reference this as the Pain Relief Act. Is that the name of the New York law?
No, that's the federal statute.
Okay.
New York has several bills. I believe the bills have different names for the program.
Okay. But that's, so it's a national right then, being a federal law?
To protect physicians?
Yes. So palliative care is now ingrained in medicine. It's widely accepted. And as long as medical practices are followed, standard medical practices, you can hasten the patient's death with the prescriptions. And on the palliative side, you're not limited to the second all. You can use opioids as well. So there are more variety of medications that can be used on that side of the game. So now we get down to another distinction that a lot of people and a lot of our families, our clients, conflate: hospice care and palliative care. And over the years, hospice has been a wonderful program. It has provided families with comfort, guidance, and an ability to deal with these very, very difficult emotional situations, and to do it with dignity and with a clear head about the realities of their situation. In hospice, we typically have a diagnosis of 6 months or less. And so this is someone who is, again, in a terminal phase. They're going to have a life expectancy the doctor's going to say is 6 months or less. And hospice has been built into our Medicare system. It's a covered benefit. And hospice lasts. We've had people on hospice for 2 years. So that 6 month diagnosis wasn't so good. But they keep renewing. As long as the doctor keeps saying 6 months, they keep renewing hospice, and it's benefit provided through the healthcare system, through Medicare and health insurance. Health insurance depends on the plan. And it's provided in a variety of settings. Most of our clients, I'd say 98% of our clients, want to live in their own home. And as my mother said, the only way I want to leave this house is feet first. And so hospice can be done at home. It can be done in assisted living. It can be done in a nursing home. And they have hospice facilities that accommodate people who are in this process. One of the major differences between hospice and palliative care is that when you go to hospice, you agree to stop treating. So you're not going to take the medications that are keeping you alive. You're going to agree to come off of your meds, take pain medication, but not continue to treat your condition. The newer player, hospice has been around a little bit longer, but the newer player is palliative care, which allows people to continue to treat their condition. So you can keep taking your meds, also get the pain medications and the counseling and other services that go along with it. And symptoms will be relieved as much as possible. This is anyone with a serious illness, not a terminal illness per se, but a serious illness can qualify for palliative care. And again, it can be done in the home, in assisted living, in a nursing home, or in a hospital. Private insurance, it depends. Medicare, it depends on your benefits and your treatment plan. So I think palliative care is becoming more ingrained, and Medicare is covering more of the palliative treatments over time, but it's not a guarantee. As with hospice, it is a guarantee. So you have to make sure that your physician is working on this and creates a plan that's going to be covered in the palliative spectrum. So hospice, palliative care, they tend sometimes not to play nicely in the sandbox. There are some conflicts between where patients fall. And as with all things in our American democracy, conflict over the dollars that fund each of these programs. Should there be two separate programs, palliative care and hospice care? They've grown up separate and distinct. And so you have to kind of know what you're talking about when you look at the diagnosis. You're a physician. If you're dealing with a cancer doctor, they know this very, very well. If you're dealing with a general practitioner, not so much. So make sure you have the right doctor to work with when you have someone who is in either of these situations, whether you're seeking hospice care or palliative care. These are some resources, and you do have the slides in your packet of materials. So some resources that you can look to. I won't read them all. Different organizations, websites, including this organization, that have much deeper information on the topics that we just covered. So why plan ahead? And if you don't mind, I'm going to leave the microphone. Can everybody hear me okay?
Yes.
I hate being behind that podium. So why do we plan ahead? We have these laws. We have a Family Decision-Making Act. We have the ability to do things. But as a lawyer, we deal with our clients in all phases. We go right through from the planning phase through to the administration phase. And we work with families throughout the process. Families that haven't planned get caught with a series of surprises, things that they don't anticipate, things that come up in the plan where there's either a lack of funding for the treatments that they want, or there is a lack of understanding of the wishes of the patient. And when there's ambiguity, you risk not having your wishes carried out. So we want to plan for future medical care because at some point you may not be able to speak for yourself. We want to keep control and have peace of mind. And when we look at planning, we have documents available to us. And we're going to talk about these for the rest of the session. And again, if you have questions on anything that we're talking about, I'll be happy to take them as we go. But as you sit here today, and I won't ask for a show of hands, so you're safe, you should be thinking about the what ifs. As lawyers, that's what we play, the what if game. What if I walk out the door and I get hit on the head by a steel beam and I'm unconscious and I'm laying in that hospital room and I'm there for 6 months? Who's going to pay my bills? Who's going to take care of my assets? Who's going to run my business, Sarah? Who's going to run the law firm? These are all things I was thinking about in the hospital back in March. And you can have a document in place where you appoint financial decision makers and have a team of people if you want them, 1, 2, 3. You can have a variety of different methods of executing this document. It's called a power of attorney. In a power of attorney, you appoint an agent. The agent has the ability to carry out your financial affairs in circumstances where you can't carry them out for yourself. And they can pay your bills, they can manage your assets, they can take care of a variety of financial functions on your behalf. If you have 2 or 3 kids and you want them all to work together, you really want to screw up their lives, make them agree on it. And you can appoint them jointly and have all 3 kids have to make every decision and sign every document. You could appoint all 3 children and have them act separately. And we always try to appoint as many alternates as we can, because we don't want to run out of agents. You can't predict what's going to happen to the agent either. And the power of attorney document in New York, and I see one of my colleagues, Glenn Witecki, in the back, who's very engaged in this area of aid in dying and palliative care. Glenn gave a talk on this to the New York State Bar Association, and I was sitting where you are in the audience and listened to his presentation. When we look at the power of attorney in our office, it used to be a 2 to 3 page document until 2009. When the state legislature passed a law that put in protections. Now it's a 16-page document. So a simple, short-form power of attorney is 16 pages. And it goes through a number of things that didn't used to be in the law. Good things, some of them. You can appoint a monitor. So if you're appointing an agent that you think needs supervision, you can put a monitor on and have them account to their monitor. And very often we use a CPA as the monitor. So the agent is doing all the bill paying, but they're accounting to the monitor on a monthly basis. You can provide for compensation of your agent. You can modify the document to provide for things like, I want to be at home under all circumstances possible. I want my pets to be taken care of. A lot of things in the new document that didn't used to be in the old. There is also an add-on to the new document, because in our practice we're doing planning, healthcare planning, but also financial and estate planning. And when we look at the financial side of things, very often we have to transfer assets later in life to qualify for a program called Medicaid. Medicaid is the only program that provides for home health care, nursing home care, and if you need those things at the later in life, Medicaid is the program you're going to need to get them. And sometimes you have to shift assets around to qualify, because Medicaid has financial rules. You can only have about $14,850 to qualify for Medicaid. So how do I get down to that? You can have somebody make those decisions for you, and that's a statutory gifting rider. That's what adds pages 11 through 15 to the document. And in that rider, you give your agent the ability to set up trusts, to fund the trusts, to transfer my assets, to create eligibility for Medicaid. All of those things can be done through the power of attorney. So if you trust the agent that you're appointing, you want to give them full authority. They become your alter ego. When you can't do things, they can, and you can give them a full range of authority to do all kinds of planning on your behalf. So the power of attorney is a very vital document. Healthcare proxy I mentioned earlier. A few things to know about it. Again, when you go to the hospital, they're going to give you the form every time you get admitted. You don't have to do a new healthcare proxy every time you go to the hospital. You just have to bring yours with you and put it on file. And they'll keep referring back to that healthcare proxy. In this document, the law was intended to allow only a single agent at a time. Some people appoint multiple agents, not kosher in the statute, if you will, because the medical providers should have one voice to listen to. If they have two agents and the agents conflict, you're locked. So the healthcare proxy law provides for single agents, but you again want to put alternates on, as many as you have, so that you don't run out of agents, and make sure that someone is there to make these decisions for you. Do you need a healthcare proxy and a living will? Everybody familiar with a living will? Living will is simply a declaration, a statement of your intent with regard to end-of-life decision-making. Do I want artificial nutrition and hydration? What kinds of treatments do I want at the end of life? In New York, that's not a statutory document. It's common law, we call it. So it's not really governed by the laws of New York. It's just cases. And so it doesn't have the same potency or effect as a healthcare proxy. What if I want to state what my wishes are? You can do so inside the healthcare proxy. So in the healthcare proxy document in our office, we have a set of instructions to my agent, which also serves as a living will. So it's 2 in 1. And in there, we will put wishes with regard to comfort care, medication, antibiotic treatment, nutrition, hydration. All of those should be thought about in advance and put in your document so that your agent knows when that time comes and you can't make your own decisions, they know what your wishes are. Yes?
Would the agent have to show that document to healthcare providers?
Yes.
And if it's a more open-ended instruction to the agent, and the agent is to make a decision, would that be enough for healthcare providers?
The question is, if the agent has been given instructions, but they're open-ended, they're not the specifics, and there are a lot of forms out there that people use that are 4, 5, 6 pages, if this, then that, but not if this happens. Doctors won't even read those. So we tend to try to keep it concise and be a little bit more direct. And if you have an open-ended recommendation that's open to interpretation by the agent, you're also going to say in there that my agent knows other than these instructions, my agent is aware of my wishes. And that usually opens up the door for them to make their own judgment and to act on your behalf. So there's a little art to it, to drafting the language in the healthcare proxy or the living will. And you need to really think about enough things, but not so many that it ties the medical provider up and doesn't allow them clarity in the decision making. Yeah?
The healthcare proxy is governed by state law?
It is.
So if you are a New York resident being treated in Boston, for example,
Yes.
what happens if, to your healthcare proxy if it's inconsistent with Massachusetts?
Very, very good question. And the answer is if you have a New York document and you cross state lines. Just did. If you have a New York document, but you're not in New York, you're in Boston. And we have a lot of clients that winter in Florida. And so they're going to be in Florida for 3, 4, 5 months. If they want to change their tax jurisdiction and get out of New York for income and estate taxes, they're going to be there for 183 days. That's the test. You have to be there at least 183 days to change your residence. What we very often do is we draft 2 sets of advanced directives, both power of attorney and healthcare proxy. Not just for Florida, for any state they're moving to. We will draft a set that we tell them to keep in Florida, a healthcare directive under Florida law and a power of attorney, and a set to keep in New York. The main thing is that the documents don't conflict. They absolutely need to say the exact same thing so you don't have any conflicts, but that document will ultimately be accepted in Massachusetts. But when you go up to the nurse and you say, here's my healthcare directive, they're going to look at it and say, well, I've never seen one of these before. And they're going to hand it to the charge nurse, who's going to hand it to one of the physicians, who's going to hand it to somebody that ultimately gets to the counsel for the hospital, who's going to review the document and call the person he went to law school with, who lives in New York, and email it to them, say, does this work? Is this valid under New York law? And as long as it's valid under New York law, it will get what's called full faith and credit in other states. It will be accepted. We have the same issue with the power of attorney. When you go to a bank and you hand a power of attorney to a bank teller, and it's not a document that they recognize, it's just going to take some time before that document gets accepted. Usually it will. So if you're just going over for treatment at Boston General, but you're living in New York, that document should be sufficient. And it should be adhered to. Yes. And again, when you draft it properly, it suffices both as a healthcare directive appointing an agent and also as a standalone living will. Most other states have living will statutes. New York does not. Okay. Any other questions on the healthcare proxy? Yes.
If you don't have a healthcare proxy and say you're in the hospital and there's a decision to be made, can your husband make that decision without a healthcare proxy?
So in New York, we had a little problem because we were the last state to pass the Family Health Care Decisions Act. We did so, however, in 2010. So New York was state number 49. I'm sorry, there was one other state. I think Louisiana didn't have one. So New York has a statute now that does allow family members, and there's a pecking order in the statute, spouse, children, parents, etc., that does allow them to make surrogate health care decisions for you. So in the absence of the healthcare proxy, you do have this statute to rely on, the prioritized list of individuals, and it can get to withdrawal or withholding of life-sustaining treatments. And where we try to keep our clients is out of this. Court. Good planning keeps you out of the court system. And if we can do that, we're serving you well. Because when you get to court, our meter starts running. Not only our meter, but there's lawyers on the other side, and their meter's running too. And court processes are delayed, protracted, and very expensive. So good planning can keep you out of that morass of litigation. And with the Healthcare Decision-Making Act, you'll see there that it isn't a court, but it's an ethics committee. So if there are issues, what is medical treatment? What is life-sustaining treatment? There are, again, clear lines and very blurry lines. Is antibiotic treatment artificial life support, or is it medical treatment? And if you don't specifically have a directive saying that you don't want antibiotic treatment, can the physician not prescribe it? Question for an ethics panel. Yes?
So
Suppose you have a perfectly valid healthcare proxy and the agent chooses to ignore it and does not abide by its directions. Now what happens?
So the question becomes, if you have a healthcare proxy and you've put instructions in the proxy and you've appointed someone that you really thought you trusted, but they're not abiding by your wishes. They're not following your directions. This is one reason, and in the bar we have a debate. There are a group of practitioners that say, do a separate living will and a separate healthcare proxy, and have the agent just give the doctor the healthcare proxy so that they have carte blanche authority. But if the doctor refuses their wishes, then they can produce the living will, which would be evidence of the patient's intent. My fear is that the living will never comes out of the pocket. And that's one of the reasons that we put the instructional language in the document. It's inside the healthcare proxy. So when the agent gives them the healthcare proxy, they're giving them your wishes. And if the agent fails to abide by your wishes, then the physician can take them to task, and they can go to that ethics committee, and they can then seek to enforce the terms of the healthcare proxy that the agent is refusing to abide by. So again, it's a balancing act. You want to be clear, unambiguous, relatively specific, but you don't want to bog it down into situations where the interpretation becomes very difficult because you have so many conditions on the decision. So that's the language that you want to craft into that healthcare proxy, but that's the best defense that you have. Other than that, choose a new agent. Find somebody that's going to do things. And a lot of times people will not appoint their children, or at least some of the children, because they're too emotional. They're too tied to the parent. And they'd want to keep the parent around no matter what the situation was, because they just can't face being without them. And so part of the consideration in choosing your agent is not just someone who can think clearly, but someone who can overcome emotion and make difficult decisions under those circumstances. Not easy to do. I've done it for 2 family members, my dad being one. Very difficult situation. But I knew what he wanted, which made it much, much easier. Yes?
I heard you earlier say that if the specific instructions are too long and complicated, that it comes out of the pocket and the doctor just says, it just...
I've seen that happen.
So then what happens in reality?
Then they're going to make pragmatic decisions based upon what they know. And Harvard published this chart. I think it was the 4 wishes. And it was 5 wishes. Pages that unfolded. And a chart that the providers had to read across and try to come to grips with all of the different preconditions that would lead. It was like a Rubik's Cube to get to the final solution. Well, at least for this doctor. And he said, I can't interpret this. I can't make sense of it. So they went with the agent's interpretation. And that's a difficult situation. Okay, so...
Are hospitals and physicians, are they obliged to honor that?
Yes.
What if they say no? It violates their religious beliefs or what?
Yeah, that if you have just a living will, it's a much more difficult case because there's no automatic enforcement. If you have the healthcare proxy and you're working through the healthcare proxy, in the public health law, there is a requirement that the medical providers follow the wishes and follow the agent's instruction. And we've had to call the Department of Health because hospitals have refused to follow the instructions of the agent. And the Department of Health came out and enforced the document. They were very prompt and very good with it. Again, the healthcare proxy law has worked very, very well, both from the standpoint of simplicity and enforceability. Yeah?
If I want to use marijuana for pain,
Where are we going after lunch?
where is that legal? How do I do that?
Okay, so you're talking about pain treatment and using marijuana for pain treatment. Those laws obviously are very much in flux. We do have the laws now. So you need a prescription, you need a fulfillment facility, and you need to do it through your doctor.
Are the physicians the one who authorized to authorize.
Absolutely. Yeah. Colorado, if you visited Colorado lately, you don't need your physician. You need your gummy bears. Because they have them, the edibles are the most popular form of marijuana in Colorado now. So they have cookies and cakes and gummy bears, and it's interesting. Yes?
I thought in New York State it was for only specific diseases,
It
like
is.
6 or something. So most people who really could benefit from it really can't right now.
It's not perfect. It is there. So you do have the ability for cancer treatment, for example, but it doesn't apply to all illnesses. So sometimes if you get refused, you have to go argue your case. And so New York is a slow state to change. And we were the last ones, one of the last states to have the healthcare proxy statute, Family Decision Act. I'm not sure why, but we're just slow. So we'll see how we do with the aid and dying legislation. We talked about the power of attorney. Guardianship is not a place you want to be, but if you don't have these documents, if you have failed to plan, then you're going to be in court and you're going to be seeking a guardianship order. And the guardianship order is limited in what the guardian can do on the healthcare side, but you can deal with end-of-life decision-making through the guardianship. It is a highly intrusive public process, and it's very costly. I'm going to turn now to a new document, something that is fairly new to most of us, and that is the medical order for life-sustaining treatment, or the MOLST form. Now, if you go to another state, you're likely to see this as a POLST, because it's a physician order for life-sustaining treatment. It's the same document. Other states' versions, MOLSTs, POLSTs. And this is a document that, and it makes sense, right? Why should you come to a lawyer and lay out all of your health care decisions? What qualifies me as your attorney to draft that language dealing with health care decisions? Shouldn't you be talking to your doctor about health care decisions? And so the MOLST form is a physician order signed by a doctor which puts your medical wishes down in writing. It's a hot pink form because it's intended for EMTs to find it and other emergency personnel to find it. And it's typically done for people who are either at home with some end-stage disease or in a facility, a hospital or a nursing home. And so this does have more specificity. This does have more detail, but it's done under the physician's guidance and written in physician speak. So this is a document that, again, they will utilize and have to, and honor. So these were not done up until, say, January with any frequency. And what changed in January that opened the door to these being done more? Medicare now has a billing code for a physician to have a discussion with their patient regarding end-of-life decision-making.
Somebody paying for it.
Medicare's paying for it, right? So this conversation can now take place between the physician and the patient, whether it be in the hospital, in the nursing home, or in the doctor's office. And if you meet the pre-qualifications, you can do the MOLST form. And now we're seeing more MOLSTs being done. It's becoming more widespread and more popular. But again, unless you have some condition that would qualify you, or you're in a facility, then this document is not going to be your choice. You're going to use the healthcare proxy and the other documents. This is one that most people don't have. I have fun with this document. We're talking about end of life, and that's a discussion that's very difficult. A lot of heavy stuff here today. But let's talk about afterlife. Where do we go when we die? I'm not going to answer that question today. Well, let's talk about that, because who are we? Does our spirit leave the body? What happens to the body? That I can talk about. And a lot of strange things happen to people's bodies when they die. Anybody know where Casey Kasem is buried? Remember him, the disc jockey? America's Top 40, Casey Kasem? They're still fighting. I've met them. They're fascinating, and they have a foundation now to pass legislation, and the issue for them was the children didn't have any right to see their father. He had a third wife that basically kidnapped him out of the hospital, took him to her home in Washington, let him die. The daughter couldn't find him at first, went to court in California, got a court order there, couldn't enforce it because he was in Washington, and then finally found him, had to go to Washington, litigate it there, got a court order from Washington, got him out of the third wife's house, got him into a hospital, and he died 7 days later on Father's Day. That's the Casey Kasem story. Who gets the body? The wife. What does she do with it? She ships it to Montreal, where it sits in the airport. And they're trying to get a court order to bring it back. And then she has it flown to Norway. He had no connection to Norway, but Casey Kasem is buried in Norway. And the kids had no say in the matter. Ted Williams. His son was kind of swept into this cryogenic phase. And he was courted by these physicians who were cryogenists from Arizona who said, your father is a very valuable man, and his eyes are the keenest eyes. He's the last man to hit 400 in the major leagues. World Series starts tonight. Good story for that. So he played for the Boston Red Sox, and his son was convinced that if he was able to freeze his father, that they could someday bring him back and use his genes to implant into people to give them better eyesight. There's a book about it. You can Google Ted Williams and you'll get the whole story in the book. So he had his father sign this little handwritten piece of paper while he was in the hospital saying that he wanted to be cryogenically frozen. Ted Williams' will, which was litigated in court, this was in Florida, he lived in Florida, said, I want to be cremated. And he was a big fisherman. If you didn't know, he was in the Sears catalog. He had about 12 pages of fishing equipment. And he had a fishing boat in the Gulf of Mexico, and he wanted his ashes sprinkled off the back of the fishing boat. That's what it said in his will. Well, the will is not a good place to put these wishes, because when they went to court, the handwritten note prevailed over the will. And so they froze him when he died, packed him in ice, and shipped him to Arizona, where they surgically decapitated him. And if you Google Ted Williams now, they'll have pictures of these big silver stainless steel vats of liquid nitrogen. And his head's in one, and his body's in the other. Frozen in perpetuity. Until science can bring him back and put him back together and bring him back to life. I saw that movie. It's called Frankenstein, right? So that's a true story. And so there were a lot of cases like that. I could go on and on. When you die, who gets control of your body? Who has the right to take control? And in many cases, it's not the person you want. And in New York, this statute really grew up because of the gay community, mainly in New York City, who had 30, 40, 50-year relationships, and one partner died, and the mother came in. And the family came in and obliterated the wishes of the individual and put them through the religious ceremonies and all the things that they never wanted, and the partner had no say in the matter. So that's where the legislation emanated from, but it really applies in a lot of situations. You can take control even after you die with a disposition of remains appointment, which is a document, just like the healthcare proxy, that appoints someone to take control for you. And it allows you to put your wishes in. And this is where we get creative. I have clients that are going to be on the 9th hole of Wolfert's Roost Country Club. They're going to be up in the Adirondacks. They're going to be, the best one I have is they want to take the whole family to the Bahamas, and they want to be sprinkled, because they use a vacation in the Bahamas. They want to be sprinkled in the water in the Bahamas, so the family's going on a trip. And you can put in there whatever your religious beliefs are: funeral, burial, cemetery, cremation, disposition of ashes. Take control, appoint agents, appoint successors, and no one has refused to do this yet. We've been doing it now for about 6 or 7 years in our practice, fairly new law. No one has refused, and we've had some situations where families have come back, mom or dad passed, And they said, it was so easy. We didn't have to think about a thing. It was all there for us. We didn't have to fight about it. You know, they squabble, well, we're going to use this funeral home. No, we're going to use that. He wanted to be cremated. No, he wanted to be buried. Take away the mystery. Do the favor for your kids. Have this document in place. And when that time comes, as a family member, you're very comforted by knowing what the wishes were. Just like at the end of life, in the afterlife. Same concept. Yeah.
And that's a Department of Health form, isn't it?
It is. It is, yes. Another statute. We got this one right. New York got this one right. We had it before most other states. Still before. Florida still doesn't have this. Yeah.
It sounds like this would be the stated wishes of someone typed up and signed. Is that adequate?
Maybe. As long as you have it witnessed, you have to have 2 independent witnesses. And the Department of Health form is available on their website. So it's pretty easy to get. So you can have the statutory framework, and you can do it that way. Okay, so those are things: power of attorney, healthcare proxy, disposition of remains appointment. They deal with you. Power of attorney deals with your stuff. Power of attorney, when you die, stops working. It doesn't have any afterlife. So what do you do to dispose of your assets? In an estate plan, you have a will. So we used to have the 3-legged stool of estate planning. It's now a 4-legged stool. Healthcare proxy, power of attorney, disposition of remains appointment, and a will. And a will disposes of your assets, appoints an executor, can create trusts for your beneficiaries, whether it's your spouse or your children or special needs children. It can appoint guardians for minor children. Takes care of all the property issues, except for property that's not in probate. And this is just a caution. We have estates that come in and people say, oh, I have a will, and it divides everything 3 ways. I have 3 kids, and my 3 kids are going to share my estate. Well, usually one of the kids comes in and says, we're going to share the estate. Okay, we have to probate the will, so what are the assets that are going through the will? Well, mom has an IRA, she had an annuity, she had a life insurance policy, and she had this bank account and a brokerage account. Okay, well, who are the beneficiaries on the life insurance policy? Well, I am. The IRA, I am. The will says 3 kids, but the assets have beneficiaries that are 1 kid. The will doesn't control. The will only controls assets that are in your own name with no beneficiary. And now virtually any asset can have a beneficiary. Brokerage accounts are transfer on death, bank accounts are in trust for. You can name beneficiaries. So you need to make sure not only that the will carries out your wishes, but you've looked at every asset that you own, and you make sure that those assets thread through the will and get to the people that you want. Now, if you have 3 children named in your will, put the 3 children on your IRA. You don't want that going to your estate. You can name them directly, but make sure it's the same pattern that you have in your will. We see it all the time. Very disgruntled children who are named in the will, but not on the asset. So make sure it's the same. Yes?
Isn't it cheaper also if it doesn't have to go through probate?
Yeah, that's a very good point. Probate avoidance is a really good thing because we get paid. Again, it's a place, where do you go for probate? You go to court. Who do you need to go to court? Me. So I'm okay with probate, but my clients aren't because it costs a lot more. And so if you can avoid probate, naming beneficiaries is one way to do that. The other way we do that is through a revocable living trust, which is a document that you can create now that holds your assets. Doesn't hold the IRAs because there are tax consequences, but we're okay with that because you can name beneficiaries directly. And it will then manage those assets under your direction because you're the trustee. If you can no longer be the trustee because you're incapacitated, you have successors. And upon your death, you name the next trustees in line. They step in and they can administer that trust without having to go to court. So it's a very protective document during your lifetime to manage assets should you become incapacitated, and a very efficient document upon your death to transfer assets to the next generation. And so when we do estate planning, this is the document that we really use most heavily. And we then very often now, because we don't want our assets to be dissipated. Lord knows it took our lifetimes to accumulate them, right? You worked hard. You didn't necessarily go that on that vacation. So you could put your kids through college, but you're able to pay off your house and you've been able to accumulate some things. You don't want it to be squandered. So we do asset protection planning, and we do it through trusts for our children. So what if they get married, inherit their inheritance, and 10 years later get divorced? What happens to your family's wealth that you've left into that marriage? You can create trusts for your kids, and when you do it through a revocable trust, you're avoiding probate in your estate, and for those assets, you're avoiding probate in their estate. It's going to go on to your grandchildren, not be lost in divorce or through lawsuits. So this is a great vehicle to put that kind of a thing in place. And so we rely very heavily, again, on revocable living trusts. It is more expensive to establish because you're doing a lot of the work up front. But in the long run, it's 10-to-1 cost for probate versus what it costs you to create this plan today. Yes?
What is the difference between irrevocable and revocable?
That's a very good question. This isn't a Medicaid seminar. We do a lot of Medicaid seminars, and we'd be happy to put you on our mailing list. Our marketing director, Sarah Beach, is in the back. Raise your hand, Sarah. So if you want to get on our mailing list, we send out periodic notices of the things that we talk about. One of the things is asset protection for you for Medicaid purposes. And in order to do that, you cannot use a revocable trust because you still own it. So for that, we use an irrevocable trust. You name typically your children or someone else as trustee. You retain a lot of rights to that trust. In your packet of materials, there are a couple of guides. One is long-term care planning, and the other is Medicaid. So I wrote this earlier this year. It's fully up to date, and it talks to you about all of the Medicaid rules and the trust planning to protect your assets for Medicaid purposes. It has some flow charts on how the trust works, and that's on page 7. So if you take that out, it'll explain that irrevocable trust, asset protection, how that works for Medicaid purposes. And I will throw you a couple of nuggets for Medicaid purposes. One that most people don't really believe me when I tell them, and that is, well, let me start with a question. Where do you want to be taken care of? Where do you want to live? You want to go to a nursing home? How many people want to move into the nursing home? No one? Assisted living, maybe? How many people want to be in their home? That's most of you. Well, the cruise ship is actually cheaper than the nursing home. So if you want to be at home and you need care, that event happens, and you need care at home. New York has a very extensive Medicaid program, but they keep it very secret. And a lot of times you get very bad information about Medicaid. You go to the, I won't name names, but agencies that are charged with giving out information, and then you go to a home health agency and say, well, we need home health care. How many hours a day will Medicaid provide? And they'll say, well, you get 4 hours a day. That's all you get. The reality is that we have many clients that we get 24-hour-a-day care for through Medicaid at home. And when I talked about hospice being available through Medicare, how many hours a day does hospice provide of actual care? 1 hour a day, typically 3 days a week. Everything else is all of the ancillary services. It's not a program designed to be a caregiving program. The only program that does give care is Medicaid. And the only way to get Medicaid is to be financially qualified. So today is October 25th, right? We have 6 days left in the month of October. If you have all your ducks in a row and you came to our office today and said, I need to get Medicaid, how quickly can you get it? I own a house, I have bank accounts, I have brokerage accounts. How quickly can I get Medicaid? I want to be taken care of at home. Your answer would be? 10 years.
Till your money runs out.
Till your money runs out. Most people think 5 years. They hear about a 5-year look back. We'll have you eligible for Medicaid on November 1st.
How?
How, she asks. I thought nobody was going to ask how. For Medicaid home care, you have to get down to that $14,850. But there's no look-back period. So we can create that Medicaid trust for you today. We can shift all your assets in tomorrow. By November 1st, you're eligible for Medicaid. IRAs, 401ks, retirement accounts are already exempt for Medicaid. We don't need to put them in the trust. So typically your home, your bank accounts, your brokerage accounts, other real estate would go into that trust. And for home care, there's no look back. There's no waiting period, no penalty period. The other side of this coin is that Medicaid allows you to keep a whopping $845 a month of income if you're an individual. Married rules are different. The well spouse, we call it, gets a little more money and a little more income, $3,000 a month. But the Medicaid applicant gets $845. But what they don't tell you is that there's another type of trust that we can use to take all your income over the $845, put it in, and then have them pay your bills. So in effect, you keep all of your assets, you keep all of your income, and New York Medicaid provides up to, not in every case, but up to 24/7 care at home, and that can be obtained the next month. So you're all looking at me like I'm crazy. We do this every day. This is what we do. And we have one attorney, my associate Frank Hemming, who's been on our radio show a number of times. This is all he does. Day in, day out. Question?
I'm confused because I understood that to qualify for Medicaid, if you have assets, and you transfer them within a 5-year period prior to your application,
right.
The presumption is you're transferring them in order to qualify.
Correct.
So obviously I'm confusing different things.
We have 2 Medicaid programs. One pertains to home health care, which is the one that I was just describing to you, and the other that pertains to nursing home care. And if you need to go into a nursing home, that 5-year look-back applies, and there's a penalty period. And generally, for nursing home people, we can save half of your assets, but not all. Those rules don't apply to home care. And that's what they don't tell you. When you go to your local social service department, you go to the agencies, they don't tell you how to get to that Medicaid home care, and that you can do it virtually immediately. Next month, you can be eligible for home care. No waiting, no 5-year look back. And so that's how we get our clients on. And your income can be saved and preserved using that other trust called the pooled trust. Done every day. Yeah.
Does it all depend on your medical diagnosis?
Well, you have to be qualified for care. So you have to be disabled. And that's a disability determination. Oh, God, no. No, chronic conditions. This is for people who need care for chronic conditions. And that could be any chronic condition. And they do if you're not already disabled, they do an independent disability determination, but it's under the Social Security rules. So if you think about getting Social Security disability, what does that mean? That means you can't work. It's a Social Security disability definition that triggers your eligibility for Medicaid. Not terminal illness, not any of those other pre-qualifiers. Very, very simple. Social Security defined. Yes?
The Eddie just combined visiting nurse home care and hospice. That must have an influence on this, since hospice is usually predicated upon the fact that you're terminal.
Right. The VNA is a home health care provider. They provide aides. These aren't nurses typically. These are home health aides, personal care aides, or home health aides. That's usually what you're getting to take care of those chronic conditions at home. And you have things like activities of daily living. You need assistance with bathing, dressing, toileting, continence, transferring, and feeding. Those are the 6 activities of daily living. They're called ADLs. There are also things called IADLs. You don't need to be in total ADL failure to get Medicaid. You just need to meet the Social Security definition of disabled.
At any age?
At any age, yes.
And is this in all states?
No, this is New York. If you flip the line, you go to New Jersey, you go to Massachusetts actually has a pretty good home care program as well.
What about Florida?
New Jersey has none. Florida has very, very limited home care. We have brought many of our clients back. They go down at 65, right? They retire to Florida, get their condo, they're in sunny Florida, they're there for 20 years, spend all their money, or not, and now they need care. But the kids are back here. And so mom and dad come back to New York. And we have them wherever they're going to live with the child, live in Coburg Village, wherever it may be. They can qualify immediately for Medicaid home care in New York.
When did it become law?
1965. That's when the Medicaid program was brought into New York and enacted federal.
But will you have to acquire an attorney to get this?
Odds are you would need an attorney to navigate if you have assets. If you're below that $14,850 in assets and you don't have a lot of income, you're below the $845 in income, then you can really just go and apply. You don't need a lawyer for that. But if you have assets and income that you need to protect, then you're going to need an attorney to walk through that process with you. Yeah.
How is income defined?
Income is any income. Social Security, pensions, annuities, interest, dividends, rent. It's all countable, and all of your assets are countable. So this isn't a shell game. We're not hiding anything. The law, this is the law. These are the rules. And you can transfer assets and qualify for Medicaid home care. Yeah.
If today everybody in this room wants that Medicaid help, but nobody is willing to pay more taxes, where the money will come from?
That's a great question. We have certain people that haven't paid income tax for, 18 years? They're smarter than us. I don't know. The smart people don't pay tax. I pay a lot of tax. The smart people don't pay tax. So that's Medicaid. It's accessible, but you have to be medically qualified for it, and you have to be financially qualified for it. The medical part, we can tell you whether you are or not, and the financial part, we can make you eligible. That's the game. Yes?
Trust for income.
Income only.
Income only.
Right.
At what point do you look into doing that? At the point
When you apply for Medicaid. That you don't have to do in advance. Now, the other trust, the Irrevocable Medicaid Asset Protection Trust that's in your materials, you want to do that as soon as possible. Because although we can do the quick turnaround for home care, nursing home is still a 5-year look back. And so we have clients that go into home care, we get the home care eligibility right away, but a year later they have the stroke or they have the fall, and now they can't return home, now they need to go to a nursing home. So when we design the plan, we put in enough flexibility that we can go back to square one, start over, and do the planning for nursing home care. Different plan, and again, we can usually protect about half of the assets. We even have clients come in, well, my mom's been in a nursing home for 3 years. We've spent $350,000. She's got $200,000 left. What do we do? And at that stage, even, we can protect $100,000 of the $200,000, even after they've been in the nursing home under those scenarios. Yeah.
So, here's the situation. I get the Medicaid, irrevocable trust. Okay, so your amount, you can only do a certain amount. So then when you're talking about that additional income, instead of doing that full trust, which sounds like requires an attorney, if you just have any excess off of your $845 a month or whatever into the spouses, we're okay, right?
No. The only thing you can spend excess income on is medical expenses. That's the only way to spend down extra income or use the pooled trust. So most people, and we work in 25, 26 different counties. So we apply for Medicaid all over the state. And we talk to the Medicaid workers, and they say 1 in 10 home care applications uses the pool trust. So people just don't know. They're just not told. They're not educated how it works. Every client that we have uses the pool trust, but not all do. And so what they have to do each month, this is what you do if you don't have a pool trust. You have to pay the home health agency. Let's say you have $1,845 of income. That's $1,000 too much. What you have to do each month is pay the first $1,000 of home health care to the home health agency. They then certify to the agency you've met your spend down. Then the county pays the balance of the month. The next month you go back on the wheel and you do the same thing. With the pool trust, instead of spending the first $1,000 of medical expenses, you write a check to the trust for $1,000. Medicaid pays day one, and the pool trust $1,000 can then be used to pay your rent, heat, utilities, food, all of your other living expenses. It's the way people, especially younger people with disabilities, survive. Without the pool trust, they couldn't survive at home. You can't live on $8.45 in many places of the state. So this is a lifeline. Yeah?
I was just confused about what a pool trust is. Is it something that you really don't have access to most of your assets anymore for anything you want?
You don't put your assets in the pool trust. You put your assets in the Medicaid Asset Protection Trust, which is a different trust that you control. The pool trust is only for your income. And that's been around since 1993. That came in
Diagram or something?
in the Medicaid guide. It's in there. Yes. So, what are next steps? Think about your options. A lot to think about, a lot of material. At a minimum, start with the four-legged stool. Make sure that you have in place your will, your power of attorney, your health care proxy, and your disposition of remains appointment. Very simple, basic documents. Happy to sit down and talk to you about them. I can tell you that if you come in for that package, it's about $750 to get those documents done. Okay? If you want to go to the next steps, then obviously there's a more intricate discussion, and we start talking and looking at your assets and looking at your income and looking at trust planning. From there, the fees do go up. Make sure when you appoint people in your documents that you discuss with them what their roles are and what your intentions are. And we'll give you enough copies of the documents to give to all of your agents, if you choose to make sure that they know what you want and what's there. And listen to us every Saturday morning on WGY at 11 a.m. We have a radio show called Life Happens, because it does. And so we talk about all these things, and Bonnie Edelstein has been a guest on our show and talked about death with dignity and get the issues out there. We've talked about all of the kinds of topics, the Medicaid topic. In fact, this week's show is all about Medicaid and Medicaid applications, and you can call in with questions. So that's a show that we do. I want to thank the people here at Death with Dignity and Bonnie for inviting me again. All right. Thank you all.